Ex parte communication in federal civil court is not about politeness. It is not about technicalities. It is about due process. Ex parte means one side communicates with the judge about a pending matter without the other side present or notified. Federal courts are built on three structural guarantees: notice, opportunity to respond, and a clean public record. When communication bypasses those safeguards, the integrity of the case is at risk.
The Federal Rule Framework concerning ex parte communication. Ex parte communication in federal civil court is governed primarily by the Federal Rules of Civil Procedure, the Code of Conduct for United States Judges, Canon 3, A4, and 28 U.S.C. Section 455, the Federal Recusal Statute. Canon 3, A4 is clear. A judge shall not initiate, permit, or consider ex parte communications concerning a pending matter except as authorized by law. That language is deliberate. Judges are not permitted to consider private persuasion. What constitutes ex parte communication? Let's remove confusion about what ex parte communication includes. Letters to the judge arguing facts, emails to chambers discussing disputed issues, phone calls attempting to influence a ruling, submitting documents outside the filing system, third-party materials sent to affect the case. The format does not matter, but the content does. If it touches the merits, if it addresses disputed facts, if it attempts persuasion, it belongs on the docket, served on all parties. Anything else is a problem. What is clearly prohibited? Federal civil courts require that all substantive requests be filed formally, served on all parties, and made part of the record. An attorney may not call chambers to clarify an argument, email supplemental facts privately, provide evidence informally, or attempt persuasion off the record. Federal courts routinely respond by docketing the communication, issuing a corrective order, stating the material will not be considered, warning or sanctioning counsel if necessary. Case illustration: judicial exposure to outside influence. In Liljeburg v. Health Services Acquisition Corp., the Supreme Court addressed a failure of judicial disclosure under the recusal statute. The court emphasized that even the appearance of partiality can undermine confidence in the judiciary. The key takeaway is that transparency protects the legitimacy of the court. Undisclosed influence does not. Non-party interference. Federal judges frequently receive letters from family members, advocacy emails, public pressure submissions, and judges may not consider them. Standard response: forward to the clerk, place on docket if substantive, notify parties, state on the record it will not be considered. This is not optional. It protects the appellate record. Case illustration: harmless versus prejudicial exposure. In United States v. Sims, the 11th Circuit addressed issues involving improper communications and judicial exposure to outside information. The court's focus was not mere contact. It was prejudice. The appellate inquiry centers on: did the judge rely on it? Did it affect the outcome? Was fairness compromised? Improper contact alone does not automatically require reversal. Undisclosed influence that affects fairness does. What is permitted? There are narrow exceptions. Administrative or scheduling matters. Logistics may be handled outside formal filings if they are purely procedural. They confer no advantage, and they do not address substance. Even then, copying opposing counsel is best practice. Substance transforms permissibility into impropriety. Temporary restraining orders. Rule 65. Under Rule 65B of the Federal Rules of Civil Procedure, a temporary restraining order may be sought without notice, but only if immediate and irreparable injury is shown. Efforts to provide notice are certified. The order is short in duration. A prompt hearing follows. This is not a tactical shortcut. It is an emergency tool. Federal judges should scrutinize these requests carefully. Settlement conferences. Confidential settlement statements submitted directly to chambers are permitted because they are court-ordered, limited to negotiation, and separate from merits adjudication. The authorization makes the difference. If a judge receives improper ex parte material, then there are disclosure obligations. The ethical course is clear. Disclose it, allow a response, and state it will not be considered. Failure to disclose creates risk. In Remmer v. United States, the Supreme Court held that private communications with a juror about a matter pending before the court are presumptively prejudicial. While Remmer involved jurors, the structural principle applies. Secret influence threatens due process. The cure is transparency and adversarial testing. Appellate review, the 11th Circuit approach. In the 11th Circuit, appellate courts apply practical analysis. They ask, was the communication substantive? Was it disclosed? Did the judge rely on it? Did prejudice occur? Harmless error doctrine often controls. If the judge discloses and neutralizes the contact, reversal is unlikely. If undisclosed and influential, vulnerability increases. Recusal under Section 455 is evaluated under an abuse of discretion standard. The United States District Court for the Northern District of Florida follows standard federal rules. There are no unique ex parte exceptions. However, practical realities matter. The Northern District handles significant pro se and prisoner litigation. As a result, unsolicited letters are common. Improper factual submissions occur frequently. The court typically dockets the communication, states it will not be considered, maintains a clear record for appeal. The emphasis is transparency, not tolerance. Consequences of improper ex parte conduct. For attorneys, the consequences can include admonishment, striking submissions, monetary sanctions, and/or referral to disciplinary authorities. For litigants, loss of credibility, procedural delay, and/or adverse rulings can result. For judges, if impartiality might reasonably be questioned, recusal may be required. But disclosure often cures the issue. In reality, improper ex parte communication rarely helps. More often, it signals desperation, damages credibility, strengthens the opponent's position, invites appellate scrutiny. Federal judges are process-driven, and attempts to bypass procedure usually backfire. In summary, at the federal civil level, substantive ex parte communication is almost always improper. Narrow exceptions exist for administrative logistics, Emergency Rule 65(b) relief, or court-ordered settlement procedures. If it affects substance, it must be filed and served. If it attempts persuasion, it belongs on the record. If it concerns disputed facts, both sides must have notice. No secret facts, no private persuasion, no hidden influence. That is how federal civil courts preserve due process, and that is why ex parte communication, outside narrow exceptions, is not simply discouraged. It is structurally incompatible with the federal system.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.